Ours started because of a case out of the Ninth Circuit called the Milky, who was a woman who killed her kid. And she was interrogated by a detective with our sheriff's office who did not record his um, interview with her. She testified at trial and said that what she said in the interview was different than what the detective did. And they found, I think, four different rulings by judges finding him not to be credible before the trial. There was a bunch of things that our office knew about before the trial that they never disclosed. And so the Ninth Circuit ended up dismissing that case with prejudice for Brady violation. And so because our office had known about those incidents, um, our policy was a little bit different than Dan's because Dan says he doesn't want to be the repository for the information. We are absolutely the repository for the information because of the Milky decision and the need to turn it over and maybe a little bit of healthy distrust of the police who will destroy, who purge their personnel files after a certain period of time. So if you go back 10 years on an officer, we may have the materials in our office, but the agency will have purged that from their file. So we keep all that information. So we do a similar thing that Dan did. We send out a letter at least once a year. I'm not 100% positive how often we send it out, but it is to every police chief in Maricopa County and their legal counsel asking for any Brady material in their files. And so you can see the list there. It's also the copy of the letter is in the materials that were distributed earlier, so you don't need to try to read that on your screen right now. But it's basically everything that Dan was asking for, plus a little bit more. Andre had mentioned that there was new legislation in Indiana. We have legislation in Arizona that mandates it. So we don't call it the Brady list. We call it the Rule 15 disclosure database. Rule 15 is our disclosure rule. And again, kind of like Dan said, I think they named theirs the way they did because the courts assumed it would be admissible. Ours was almost 100% because cops hate the term Brady. And so we tried to take the sting out of it. But, as Jeff said, the cops hate this. They hate being on the Brady list. And it's seen as a career killer. If you're put on our Rule 15 list, a lot of times you can't promote. Some offices won't hire you. You can't transfer to a different office because you're on this list. And we try to explain to them that that's not what this is. This is a disclosure list. We have an ethical duty to disclose this information. It's not about, we don't believe you as a witness, but putting on the list is like a death knell. So the law enforcement lobby went and got this statute passed that requires us to give notice to the officer before we consider them. And there's an exception if it's something that we feel we have to get out right away. Like I think we don't do a lot of investigation. We don't disclose those unless it's like the case, that Olson case, where it's a crime lab analyst who is found to do something wrong and it may impact the findings in this case. So in those circumstances, the statute doesn't apply, but we have to give notice. We have to let them know what we're considering. We have to give them an opportunity to send us materials. And oftentimes a lawyer from the union will send us a letter about why we shouldn't include them. And then they also have the right to make a request for reconsideration. So we do a lot of appeals of this. So we've got to give them written notice. And I think I included the statute in the materials that were handed out. So I can just kind of go through this. And this is what the notice that we send to them must include. So we have a committee. We meet every 2 weeks. Recently, our Department of Corrections, who had never given us any materials, found all their personnel files and sent us dozens of files on their employees. So we started meeting every week to go over those files. There's 11 senior attorneys. They're all supervisors in our office. We have our conviction integrity attorney on there. We have mostly bureau chiefs, and I think all of our division chiefs on that. And we typically have about 10 to 15 matters. Our policy, and I've included the policy in the material so you can read through that, but we basically have two different tiers. And this was an attempt for us to kind of get past the stigma of being on the Brady list. So tier one is mandatory. That's the typical Brady list. If you're on that, it's going out in every single case, and those are your honesty violations. Tier two is it's conditional. So we have a lot of cases where we're getting that the officer had used excessive force. And to me, that's the stereotypical tier two case. Is in most cases that's not going to be Brady material. But if the charge is an aggravated assault on an officer, and the defense is that it is self-defense or the officer started it, then now that use of force is conditionally relevant. And so we created that tier two to allow people to disclose. So a lot of times our attorneys they feel like their bar card is on the line. We're saying, hey, this isn't Brady material. You don't need to disclose it. They want to do it anyway. So tier two was a way for them to be able to disclose something that we didn't think was relevant in all cases. Now, what we found is if we make something tier two, our attorneys are disclosing it close to 100% of the time. And we give them the option. Tier two means you can disclose it, you can look at it and determine that it's not discoverable and not disclose it, or you can disclose it and just follow your motion in limine to keep it out of court. But most of them just disclose it because they don't want to deal with not disclosing it. So I wanted to show you a little bit of what it looks like on our committee and what we review. So this would be one that our sheriff's office said to us, and you can see that there's an allegation of untruthfulness that was sustained. And so this one's easy. This one is going to take us 10 seconds. We're going to say we have a finding of untruthfulness. This is going to go on tier one. This is one of those that is a excessive force. And so this one, I think I voted to put this officer on tier two because, again, the finding that they used the force on one inmate isn't going to be Brady in most cases. But if there's an allegation of, or if the charge is one of assault, then this may become relevant. So this is going to be tier two. I jumped the gun on this one. This is what our choices are. Tier two, disclose and file the motion, or not disclose. Once we make our determination, then we send out an email to the entire office. So everyone in the office is going to get this email. The committee met. These are the people who have been added, and these are the people who were reviewed and not added. So if you have those attorneys who either know that something considered, they know that that officer wasn't put on, or they can go and try to find that information. And then we include with it a spreadsheet for the officers that were added, so they can look and see, do they have any cases on the list? So we have over 300 criminal attorneys in our office, and so it's hard to notify each of them individually. So they just get this spreadsheet, and then they can go through and determine whether or not they have someone on the list. This is kind of similar to what Dan was saying. On ours, we don't call it the PID. It's called Rule 15. So it will be next to their name when you add them as a witness in the case. So if I get a case today and someone's on the Rule 15 list and I add them as a witness, I'll get a pop-up that says they're on Rule 15. And then anytime I look in the file, I can see their Rule 15 on the list. And this was what made me laugh on Dan's presentation. We have the same exact button. It's customizable. Ours doesn't say PID. Ours, it says Rule 15. And we have the same thing. We have a summary of what the officer gave false information. And then here are the materials to open up and disclose. So almost exactly the same way that Dan does it in TBK. So other issues we have a similar rule about the disclosure rules about disclosing felonies and misdemeanors of moral turpitude. So we don't have to disclose all misdemeanors. So DUIs we generally won't disclose, but then we start reading the facts of the case and the person says, you know what, I haven't been drinking, but their BAC is a .20. And so we know that they've lied to the police when they were stopped because they couldn't not have been drinking. And so we've had that debate of, do we have to add them because we know they've lied even though there's no finding of dishonesty? And we go back and forth on that one. We used to, like on cases like that, we might ask for judges to do in-camera review before they disclosed. And initially our tier two was required an in-camera review. but the judges won't do it. And they just disclosed everything. So we just did away with the requirement for in-camera review. We've asked for guidance from the court, and I've kind of informally created a tier 3, which is we don't know what the hell to do with this. And I've asked our Supreme Court to convene a committee of prosecutors, defense attorneys, judges, cops, to talk about the Brady list and what some standards can come out about it. It's gotten no traction. I would love to see it happen, and we have those sort of committees on other things, but we just haven't had one. But it would be nice to get some guidance, not in a decision, but on from the courts informally. Hey, this is what disclosure is required. And then one other issue is, what do you do with the prosecutor referrals? And this kind of hits close to home for me, because we have these cases where the prosecutor will say, you know what, I think this officer lied on the stand. Or I was watching body-worn camera and I think the officer did something wrong. We, like Dan said, we want the officers to investigate. So we had a case where a detective testified at grand jury that the suspect said something to her in the interview. And during trial prep, we got the video of the interview, and the suspect didn't say that at all. And so the attorneys were very concerned that the officer had just made it up, and came to me. I was the supervisor at the time. And what I did was I wrote a memo to our committee, our Rule 15 committee, saying, hey, there's this allegation that the officer said something that wasn't true at grand jury. Can we have Phoenix investigate and give us a finding on it? And of course, it had already been disclosed to the attorneys in that case because they had the video, they had the statements in court. But we sent it to Phoenix. Phoenix did nothing with it. It was sitting out there for a year. And we ended up having a capital case dismissed with prejudice because that witness, that officer, was the case agent. There were allegations in her case that she had also done the same thing, and we had never disclosed it. And so the minute entry dismissing that case with prejudice lists the Kalish memo to our committee that our attorney never disclosed. And so what do you do with those cases? Because you don't want our attorneys to be the witnesses. You don't want to put them as the witness to misconduct. And if the agency won't investigate it, what do you do with it? So there needs to be a solution to that. Our perfect world, and what we would love to see, and I'm not sure, I think the unions are a big holdup of it, is having the agencies just make all of their files open. And so the city of Phoenix does this a little bit, not in the context of this, but with their DUI, their misdemeanor DUIs. They put all of their DUI records online, and defense attorneys can go put in the name of the officer and pull up all of their qualifications. We would love to see the similar thing where every agency puts their complete personnel file for every officer online, including any discipline, but also any accommodation, and just put that online and take us out of it. So we don't need to review and determine whether or not it can go on a list or not. There is no Brady list. There's just the files online, and it's up to the defense attorney to go. We send them a letter saying these are available online. Here's a link, and it's their duty to go and look at it if they want to find any of that material. I don't know if we're ever going to get to that. Statewide. So we have a statewide list, but really all it is just a notice that that officer is on somebody's list. So if someone outside of Maricopa County gets a case with a Maricopa County officer or detective, then they can go to our APAC, which is our statewide prosecutor organization, put the officer's name in, and if that person is on any of the lists in Arizona from any of the offices, then it doesn't have the materials, but it will show that that officer is on a list from the Maricopa County Attorney's Office, and then they can contact our office and get the material.